government is game for a laugh, except that the laughter is not the best medicine, it's a poison chalice. I heard the minister saying that this bill is dynamic. If this is a dynamic bill, then hell will be let loose on all of us. Let me remind all our friends that since the bill was circulated on the 1st of December 23, the bold and the daring have highlighted the demerits of this legislation. It is an unprecedented legislation. Prime Minister stated earlier that there has been wide consultation with all relevant stakeholders. Who are they? He has not mentioned any of the stakeholders. He has not mentioned, and if he has said so, it has been, the meetings have been held within the periphery of four walls. There's been no wide discussion at the bar of public opinion. The public matters. The public has to be listened to, and the public has to be heard. They have a voice, and the voice has to be heard constantly. Mr. Speaker, the Prime Minister and the Minister responsible for financial services made a lengthy discourse on the virtues and advice of FATF to ensure the effectiveness of our financial services in an effective manner. But let me tell them that this bill will be an impediment and will impact upon the mutual evaluation when the time comes in 2027. There's a lethal veneer behind the surface of the Financial Crimes Commission. And may I remind the House that when we were in power and chaired the nationale committee, Mauritius was hailed as a showcase. And we did a lot to implement recommendations made by nationale. But may I remind this House that Mauritius, under the MSM-led regime, was on the grey list of FATF and the blacklist of EU due to its failings and unnecessary delay to comply fully with anti-money laundering and combating financing of terrorism. Mr. Sobrino was given a certificate of good character as a reliable investor by the regime. This regime lost valuable time to implement recommendation of FATF and Islamlag because its priority was political vendetta. And if the intent is to wage war on financial crime, the office of the DPP should not be sidelined. There should be a symbiotic relationship between the two institutions. The bill defeats the purpose. Of course, Financial Crime Commission will act selectively. Will the people's turf and expert in horse rigging be investigated? The jury and the horse racing division are lapdogs of that company. And the people's turf has been allowed to organize 24 races into successive horse racing meetings on a turf which spelled disaster to horses and riders. This is cruelty to animals and cruelty to those who ride horses. Punters are being fleeced. And up to now, the owner of this company remains untouchable. Will the Financial Crime Commission dare to investigate one of the biggest contributors to the war chest of the MSM? The country acknowledges that those who were the first to say its usurpation of the rights and obligation of the office of DPP. Indeed, the country acknowledges those who dared to say and speak up and say loud and clear its usurpation of the rights and obligation of the office of the DPP. The non-political arm of the executive should be shielded from the noxious political influence of the MSM-led regime. The leader of the opposition has highlighted the relevance and importance of Section 72, 72(3)(a) of the Constitution and the relevance of Clause 58 of the bill to discontinue an investigation. But the problem is, when the Commission decides to do a cover-up and discontinue an investigation after further investigation. As matters stand now under POCA, all cases are sent to DPP after further investigation. The reply of the Prime Minister to PQ B1706 is revealing and shocking. It's a foretaste of what this government has in mind. First amongst the equal does not mean the rights and obligations of holders of constitutional posts could be usurped. The Prime Minister cannot have access to file of cases which are being investigated. He has seen all the evidence in the case file.
May I know, because the Honourable Member is saying that I am having access to files that are being investigated.
That's what you
see. This is not in order, because I don't have access to files which are in cases which are being investigated.
But you say that you can raise and should.
Wait.
What are you talking about?
So you listen to me. You listen to my ruling. Can you? So if you said that the Prime Minister is reading from file which is being investigated, you apologize for that because that case has been already done. Because you said it. You won't apologize? You won't apologize?
Apologize for what?
You won't apologize for what you've done?
You want me to apologize? All right, I'll apologize.
Oh.
All right. If that is so, all right. Okay. 1,001 apologies, Mr. Speaker. Mr. Speaker, what we have seen is what we are seeing is a déjà vu phenomenon. The object of the Public Prosecution Commission legislation of 2016 was to turn the DPP into an errand boy and the office of the DPP into a rubber stamp. Government is government, and government so decides. The agenda was political. The MSM-led regime would have never mustered the qualified three-quarter majority vote. The nation applauded the leader of PMSD and members of his party who did not hesitate to withdraw from the government, as the political arm of the executive was hell-bent to undermine the office of the DPP, a non-political arm of the executive. This is a laudable and praiseworthy action. Will the leader of the ML dare? After all, he was the former chairman of the Select Committee on Combating Fraud and Corruption, which helped to frame the Prevention of Corruption Act. Mr. Speaker, we stand united, and I'm glad that all opposition parties, NGOs, trade unions, members of the legal profession are fully on board to put up a common front, not only toward a threat, but to say stop the gross violation of our fundamental rights. The Bar Council has come up with a host of proposals and has solicited an urgent meeting with the Attorney General. As usual, he has chosen to go on hunting expedition. A meeting is now scheduled for Thursday. This is as bad as a contempt. The indifference and insensitiveness is absolutely shocking. The nation has taken note. Rushing this bill through with a certificate of urgency against the backdrop of festive season is evident that the regime is desperate. It is out of breath and out of depth. Consolidation and streaming of the financial services as an apex body is a different scenario to a weaker law. La loi scélérate, la loi Bayon. This bill should be confined to the dustbin of history, Mr. Speaker. Using the tyranny of numbers to vote a bill by simple majority is a tragedy of justice. To all intents and purposes of governance, accountability and transparency, a qualified majority of three-quarters should have been the order of this legislation. What may be legal under false pretenses is not legitimate. The test of constitutionality is inevitable. Those who are well-versed have referred to Section 1, 2, and 72 of our Constitution. There's a vast difference between sacrosanctity and sacrilegious legislation. The bill is being introduced 1 year before general election to target political opponents first and foremost. Should I remind the House of the number of illegal, arbitrary arrests, the special cell set up at Line Barracks with instruction relayed from Government House as to whom should be the next target? The list is long. I have seen it all. And the cruelty of the MSM knows no bounds. Who cares when the Director General of the Financial Crime Commission is judge and party? But beware of the wrath of the public. The public neither forgives nor forgets. The bill has compounded the fury over the regulation of ICTA Act to register SIM cards with collection of biometric data like facial scan. May I remind the House that the electoral process can be wrecked by artificial intelligence with high-fidelity misinformation. And it's all part of a noxious political agenda of the MSM for the forthcoming general election. The art of rigging and arbitrary arrests is looking at you kids. Who are the first to shake in the boots? The staff are the first target. The decent staff of Good Governance Integrity Reporting Agency, the Asset Recovery Investigation Division, the Financial Intelligence Unit, and the ICAC. Beware, this bill does not provide security, does not provide safety and certainty of employment to the staff. Clause 167, Section 5 and 7 of this Act says it all. The bill being used to replace them with a personnel which will bend backwards to please the Director General. It's the yes Prime Minister, yes Director General syndrome. Mr. Speaker, the way the directors appointed under Section 10 of the bill is absolutely shocking. And the Leader of the Opposition made a laudable proposal. Why is he not appointed by the local Judicial Service Commission like the Electoral Commissioner? An appointment committee with a president who is a PM's man is a sham. He will be the custodian of our Constitution if he plucks the courage and refuses to give assent to this bill. Then we can say that he is the custodian of our Constitution. But then the president is the Prime Minister's man. We all know that. Honorable Colin Davelou in 2001 was instrumental, I've stated earlier, as chair of Select Committee on Fraud and Corruption to set up ICAC under POCA. But it was a member of the Select Committee. I was a member of that Select Committee, and I recall, and resourceful MP under his stewardship. He was for the setting up of triumvirate to appoint the director of ICAC with the parliamentary committee as check and balance. Unfortunately, both the director of ICAC and the chairperson of the parliamentary committee had a clear-cut agenda to frustrate the members of the opposition of the committee and to sack Mr. Bader, who was then investigating officer of ICAC. The director of ICAC has been faithful to his ways and means. He runs the independent commission as he deems fit, selectively, arbitrarily, and arrogantly. Mr. Speaker, the fact that the Director General is not accountable to his decision. The Operation Review Committee, as we know, is a bulldog with no tooth. And as to the Parliamentary Committee of ICAC, it has been castrated. The provisions in the bill to set up the same Parliamentary Committee is adding insult to injury. And the 4 opposition members of the Parliamentary Committee of ICAC, appointed by the Leader of Opposition, had no choice but to walk out. And I'm told that the Parliamentary Committee has not met since last May. Legitimate questions were put to the Director, and he refused to reply on privileges attached to his status, on his wages and salaries, on his overseas trip to London. As of now, the population is yet to be apprised as to why he made a U-turn when the Medpoint saga on conflict of interest was heard before the Privy Council in January 2019. He had no business to be there. He knew that the institution had not been granted a right to audience, so why did he go and sat himself there at the expense of taxpayers? Mr. Speaker, do you know the Director General can initiate proceedings without a judge's order? He has power to arrest. Section 55(1)(2) of the bill, the preliminary investigation by the Commission, gives him unfettered powers. And that's what it says. The Commission shall, on receipt of the report under Section 2, make a determination as to proceed with further investigation or be to discontinue the investigation. He so decides, and he doesn't have to motivate his decision. He wants to play God when he's not even the lesser God. Section 56, referral to commission. This is what I call the referral process. The DPP has to refer to the Director General as more general. This is not delegation of powers, but uncontrolled submission. It's a retreat and surrender by the office of the DPP to the Director General on cases of financial crime. An insult to Section 47 of POCA. Under Section 47 of Prevention of Corruption Act, no case has been set aside or prosecuted without the consent of the office of the DPP. As late Madame Gajador, an eminent lawyer, stated, the Director of Public Prosecution is next to God. Even God or lesser God is not above the law. The former DPP had set a pattern in the name of good governance to motivate the decisions of the office of DPP in relevant cases. Section 66, the special investigative technique. This is what I call the KGB method surveillance. The Director General shall give his approval under Section 1 or 2 after being satisfied that it is just, proportionate, and in public interest to do so. These are intrusive powers without any safeguard. It's KGB at work. When an ex parte application is made to the judge, don't be surprised if there is reasonable ground to arrest a suspect with low threshold of mere suspicion. In the meantime, the suspect may be arrested and spent years in court to clear his name and reputation. Does anybody know for how long the phone of a suspect will be tapped or a person will be under surveillance? Of course, Prime Minister will say regulations will be drafted under Clause 164. The fact, Mr. Speaker, that he can come in lawyer's office, and that we have to understand very clearly, the unfettered powers conferred upon the Director General. The fact that he can come in lawyer's office and take the documents as part of an investigation. The powers of investigation are scary, notwithstanding the means they can use. Monitoring, surveillance, phone tapping. Big Brother is indeed watching. What happens to privilege between client and barrister? Do they have to fly over the cuckoo's nest? Can a member of the legal profession put up or shut up? Of course not. The lawyer, the attorney, the notary has to stand up. As we say, arise, awake, and stop not till the bill is withdrawn. The battle is here, in this house and out there on all fronts. It is the tyranny of numbers which will get this bill through with a single majority. Well, this is what I call the indecent vote. This is indecency. No decent person or institution can remain insensitive or indifferent to the provision of the bill. Thank you very much.